So welcome everyone to this Lunch and Learn session, another in my series, my DNA of Business series of Lunch and Learns. And my name is John Denton, and it's my pleasure to welcome you all here today onto this web meeting. So I work with business owners. My role in life is to help business owners get their businesses into a saleable state, to turn their business into a saleable asset, and help them prepare their businesses ready for sale, regardless of whether a business owner wants to sell now, down the track, or sell multiple times like a franchise. But if you've got a business that's ready for sale, then it's well worth keeping. And I do that through one-on-one mentoring with business owners and also with my advanced mentoring groups. And I run these Lunch and Learn sessions, which are a freebie to anyone and everyone, and I get guest expert speakers to come on sometimes, and sometimes it's just myself. And if you're watching the recording of this, then in this corner up here, from time to time, you'll get little tabs with an eye symbol on, which will give you, you can click on to get more information and suggestions of other videos to watch. Today is one of those days where I have a guest speaker, and it's my pleasure to introduce Helen Kay from Rise Legal. So, hi Helen.
Hi John, hi everyone.
I've known Helen for a long time. Helen is the owner of Rise Legal Business Lawyers. And in the past, during my business broking days particularly, I've referred people to Helen and friends to Helen as well, to help with commercial leases and all sorts of things. And Helen always gets rave reviews, which is good. So Helen, it's over to you now to give us some tips on getting paid for what we do and hopefully negotiating rent reductions for those who have commercial leases. So it's all over to you.
Thanks, John. As John said, I am a business lawyer and owner of Rise Legal. And in a previous life, pre-COVID, I was helping businesses move forward with their growth strategies. So helping them get their businesses ready for sale, maybe acquiring a competitor, leasing new premises, all that exciting commercial legal stuff. And obviously, as we've all had to in recent years and recent months, I've had to pivot quite quickly. And what I did was I actually sat down and reevaluated what my target client's pain point was, and very quickly identified it's not rocket science, but that's the need to have cash available to them. And so I thought, well, how can I help them do that in a way that's legal? And I've started offering my help with restructuring how people get paid and their protections behind that, as well as constantly talking to commercial tenants about their rent relief. So I'll just share my screen. So, so today I'm talking about cash is king and how to make sure that you can keep as much of it in your own bank account as possible. So to do that, I want to talk to you about how to make sure you get paid for the work that you've got, and also negotiating rent relief with your landlord. So my thought process is that we are all in business for one reason and one reason alone, and that is to earn an income. I don't think there's anybody who actually just does it for the fun of it. And as I mentioned, cash flow is more important than ever right now, and you really do need to accelerate your cash collections. So this webinar is directed at anyone who provides services and doesn't get paid for any work up front. So basically everybody. Times are tough, and attracting new clients is going to be harder than it was. So you need to make sure you get paid for every single job that you do, and you can't afford to be complacent. You need to earn that income for your family. Like I say, accelerate your cash flow collections, and don't be complacent. So the first thing, I sat down and I brainstormed how I could help my clients make sure that they do get paid. And the first thing that you really need to look at is the payment structures that you currently have. It might just be the way you've always done things. We can't do things the way we've always done things anymore. We have to actually look and see where we can make positive changes for our own benefit. The first one is the payment structures that you have in place. And here are my recommendations for the things that you should be looking at. And I will say as well, just before I go any further, that I have shared a resource with John, which is essentially a blog that sets all of this out, as well as some free downloads. So you can have that afterwards, and so you don't need to make notes of what I'm saying at the moment. And a lot of this will seem obvious, but just, you know, even if one of these things resonates and it helps you with your cash flow collection, then, you know, my job's done. First thing is to see if you can get some money up front. I know lots of people don't like to charge deposits or things like that. I think now more than ever is time to actually start asking for some money up front. Either get a large deposit or an initial payment, because that obviously mitigates your loss to a certain extent, because before you even start a job, you've got some money in your account. But just be aware that if you are taking non-refundable deposits, that there are rules in the Australian consumer law about non-refundable deposits specifically. Now, they're only allowed where the buyer is actually aware of that fee before they sign the contract with you. People often phone me and ask how much deposit they can actually take. And the rule is a fairness rule. It basically says that non-refundable deposits should be reasonable and protect a legitimate business interest. They should be proportionate to their business costs and time, and should not penalise the buyer as being unfair. So if you start asking for, I don't know, 80% up front, and yet you've not actually done any back work. So, you know, a cabinet maker, for example, could ask for a lot because they've obviously got to go and buy the product and then spend time preparing the product to bespoke measurements, and then going and getting it, you know, seal painted, etc. for that particular client. So they would be considerably out of pocket if somebody turned around and cancelled the job. Whereas a lawyer, like myself, wouldn't really, because if I haven't actually started the work yet, then there's no reason why I should have asked for a big deposit up front. Second thing you could think about is whether you can charge in stage payments. So this is something that I do for business sales, and I set out very clearly for the client what the sort of 3 or 4 different stages of the sale process are. Give them a fixed fee for the whole job, but then stage pay as we go along, and made it very, very clear in my client agreement at what stage they will be charged and what percentage of the final amount that they will be charged. It's very important to get that in writing, and I can't stress how important it is with whatever you agree with your client to keep a paper trail, because you're going to need to point to that at some point if you need to rely on it. Another thing which has become quite apparent, particularly with inability to get materials out of China recently, is actually the ability to suspend services. So I've had quite a few clients who had some issues with, obviously jobs were delayed because they couldn't get product out, and there was nothing in their agreement with their client that said that they could delay services or suspend services for a reasonable period. You also want to make sure that you can suspend services if you've not been paid. So again, this helps with the stage payment. You see how it all sits together. So if you've not been paid for stage 1, you don't then progress into stage 2. But this all has to have been set out in writing with the client. Something that I always recommend my clients do as well, particularly for large value jobs where they're contracting with a company rather than the individuals, is to draw those individuals out from behind the shield of the company and get personal guarantees from the directors. That's perfectly reasonable, and the whole reason why you set up a company is to get that protection, hiding behind a $1 company. So there's no reason why you should expose yourselves by contracting with a $1 company. So if anyone's not sure about that, I'm happy to have a chat with you about how you can do that, but it's perfectly normal. If you sign up for some legal software, if you any software, if you sign up for anything, you know, on higher terms, etc., you would be asked to personally guarantee those terms. So there's no reason why you shouldn't as a service provider. And also change your payment practices. So think about, this will be harder with existing clients, obviously, but if you've got new clients coming on board, then have a think about the way in which you're going to bill them in the periods. So if you're currently working on, say, 60-day payment terms, maybe change it to 30 days, maybe change it to less than that. And as long as you communicate that up front, then they've made that deal with you right at the start. So there's no confusion on their part. One of the main things, I'll just give you an example before I get into this. I took a phone call from a client the other day who was very sadly owed $18,000 for a job they'd done. And obviously they told me the full story, and then, you know, half an hour later I said to them, can you please send me your invoice for this client that's unpaid, as well as your client agreement? And there was silence on the end of the phone, and there's no client agreement. So there was absolutely nothing in place with this client, bar a series of emails that had gone backwards and forward about the price and some other technical issues, but absolutely no terms and conditions, nothing which I needed to point to payment terms, ability to charge interest, and ability to charge debt collection fees. Now, it is actually illegal to write to a company and tell them that they owe you money and they owe your lawyer money if you don't have that in your terms and conditions. And lawyers can get a lot of trouble for that, and so can debt collection companies. So it's very, very important. You do have most terms and conditions are 2 or 3 pages. They're very standard, and you know, just protect you in these types of instances. So I just wanted to run through the very high-level things of what you need in a well-drafted set of terms and conditions. And like I say, I've shared a resource with John, which actually has a download, and the download is the 7 clauses that you have to have in your terms and conditions right now. I've not done a typical lawyer thing in which I've given you those conceptually, you know, and said you need a suspension clause or you need a delay clause. I've actually given you a clause that you can copy paste from that download into your terms. And if you're not sure where to put them, then I'm happy to have a quick chat with you about where to put those clauses, because I actually want to make sure you've all got them in there in case you need them. So the first thing is obviously agree the price. You'd be surprised how many times there's arguments about what the actual price agreed between people is. If you've got that on a quote, then, you know, there's no argument. That's the quote and it was accepted by the client. How payment can be made and when it's to be paid. So again, if you do adopt those stage payments that I recommended, then that's all set out, and even making it clear in there what your payment terms are in terms of, you know, date of payment from invoice. Your ability to charge interest on late payment. This isn't something that you are entitled to do at law. If you need the contractual right to charge interest, and it's perfectly reasonable. If someone's not paid you on time, you should be able to charge a reasonable, not a penalty interest. So we need to get that in some terms and conditions for you. And going back to that example that I just had, you do need the ability in your terms and conditions to charge for debt recovery costs. Otherwise, you'll have to bear the cost of that. So you have to have a clause that says that if you engage debt collection services, that it's at the cost of the client. Termination provisions. Now, this is interesting. If there's an issue with the client, so they've not paid you, or if they're asking you to do something unreasonable, or just not providing you with the instructions that you need to get to the next step, you really do need the ability to be able to terminate the contract with them and walk away and actually go to a client that you do want to deal with. Again, this needs to be very clearly set out in some terms and conditions as to how you can terminate and when you can terminate. You know, for example, immediately if there's a fundamental breach by the client, or on 30 days notice at either party's discretion. Delay. Now again, getting back to these poor people who couldn't get the product out of China, they need to have a no liability for delay clause in their contract, and that's also for people who know contract law. That's called a force majeure clause, which basically means that there's that you won't be liable for any delay or failure to perform your obligations if the delay is due to any circumstance beyond your reasonable control. Without that, unfortunately, some service providers were finding themselves in breach, even though it was no fault of their own, and obviously, you know, there's been some good faith between parties, but if you'd had this in your terms and conditions, you would have easily been able to invoke that clause and just explain what the delay was. And again, I've already mentioned this before, that the ability to suspend work if you need to for whatever reason, particularly if your clients don't pay you by the payment date, that you can cease to provide services until you do receive payment. So an example of this would be a couple of years ago, I was contacted by a web designer who had designed a website for somebody and hadn't been paid, but there was no contract in place, and he basically still had to go ahead and continue and finish this website. And then we negotiated, we had to do some considerable negotiation with the other party to make sure that you know, my client could actually walk away from it, etc. But had there been a contract, it would have been so easy. The client themselves could have just copy pasted the clause and said, here's, you know, pursuant to clause X, we're suspending services until payment of this invoice. And one of the other things to make sure you get paid as well, so we've touched on changing your payment practices and having some really well drafted terms and conditions. The other thing to do is to be disciplined about your invoices after you've sent them. Have a system and then follow it. So the first thing I always do is diarise all payment due dates so they don't get missed. Have basically some templates ready so that you have a template email 1, email 2. So first of all, you contact the client with a friendly reminder that that invoice is due for payment, and then have some overdue reminders that, I don't know, if you've got automation, you could actually have those so they go out automatically. And then the last point of call would be to contact a lawyer. So after you've sent maybe 2 or 3 of those overdue reminders, and it's getting quite to a point where that client's not contacted you, hasn't suggested that there's any issues with payment or tried to address any payment terms with you, that's when you need to contact the lawyer, and the lawyer can assist you with a letter of demand. And that's when I'd be asking that question, which is I need the invoices and I need the client contact. And the final thing is what happens then if you haven't been paid. So again, having systems in place for non-payment. One of the things I'm doing with clients at the moment is to contact the person who owes the money and actually try and find out from them how much they can afford to pay and over what period, and then we're documenting these payment terms. There's actually, you'll probably all know this, but there's actually a moratorium in place at the moment, and the governments have put temporary relief in for financially distressed businesses, and that relief is that you can't serve statutory demands for winding up at the moment, which is obviously where lawyers get a lot of their weight from, is serving a statutory demand because somebody needs to pay it if they want their business to continue. We can't do that for the 6-month period up to the end of September. So what I'm doing at the moment is I'm speaking to people who owe money and giving them the 2 scenarios. So the scenario 1 is that the debt keeps accruing plus interest plus debt recovery costs, i.e. my fees, and telling them what that debt looks like at 1 October. Or scenario 2 is, here's the debt, divided by 12 months with no interest, no legal fees, and this is what the debt looks like. And a lot of people are saying, where do I sign for the payment terms? Obviously knowing that, when we come out the other side of this, nobody wants to have huge debts, either with suppliers or landlords, etc. Okay, so I thought it'd be good to pause because there's 2 topics in this presentation. So I thought it'd be good to pause perhaps and ask some questions that are pertinent to the how to get paid section.
I've got terms and conditions in my agreement. I do it a little bit differently to most webbies. I'm smarter than them. So I set things up on a payment plan rather than having a milestone thing, so I don't get caught at the end myself. But how much do you charge to review current terms and conditions and agreements?
I'll talk to you after this, Peter. It's like how long's a piece of string? So I'll have a chat with you after this, if that's okay.
Okay, cool. Yeah, no worries.
Yep,
I'm just thinking I might be in trouble with Mr. Denton as well, because we're supposed to leave questions to the end, aren't we?
Yes, it would be good if you could finish the second part of your presentation, and then we'll open it up for questions. Helen, that'd be
I thought that. I prepared the presentation before you explained the lay of the land to me, so I'll carry on, and then I'll answer that question for you, Peter.
All right. Thanks, Helen.
Okay. So now on to rent relief, and that's the nice relief of flowing water and a little ripple in the water, which obviously if you can get some rent relief from your landlord, you'll feel like that. So what am I talking about? I've been talking a lot on social media recently about rent relief. And for those of you who, perhaps aren't following me on LinkedIn and stuff, or haven't been watching the news, what this is the National Cabinet a few weeks ago, a month and a bit ago now actually, sat down and said, how can we help commercial tenants through this? And they produced a mandatory code of conduct, which COVID affected tenants and landlords could follow, so that they actually had a blueprint to agree some form of rent relief between them. Leasing is a state and territory matter. So whilst the National Cabinet came down and said this is what you all should be doing, they then left it to each state and territory to legalise this into their own legislation. And they're all at various different stages of this. Some have passed enabling legislation, which enables them to make regulations about this code, and some have legalised it already. So it's basically every state and territory who've put this in place are following the national guidelines. Some have gone a little bit further, so I'm going to stick with the basics of the national guidelines. So these are that the code applies to commercial tenants who are small and medium-sized businesses. That's businesses with an annual turnover of up to 50 million, and they have to be eligible for JobKeeper payments. So that's the way in which they've determined whether a business is COVID affected. As you'll all know, that means that you have to meet the basic test for JobKeeper payment, which is a downturn in revenue of at least 30%, as well as all the other tick boxes that you've no doubt had to go through at some length with your accountant recently. So if you're in that bracket and you lease commercial tenancies, and that includes retail, office and industrial, you will be covered by the mandatory code of conduct and can go to your landlord and request rent relief. So there's been quite a lot of confusion as to what rent relief is. 50% gets bandied around. Lots of people who ring me are saying, so I get 50% off, is that right? So I'm just going to show you what it actually looks like. So for a typical tenant who, it's quite a high rent, but if you had rent at $6,000 a month and you had a COVID-related 50% loss in revenue, this is what it would look like. So you're guaranteed 50% cash flow relief, because your rent relief is your rent times by your percentage loss in turnover. So you're guaranteed at least $3,000 in cash flow relief. Of that $3,000, that then splits out. A minimum, so at least $1,500 has to be provided as rent-free, rent waiver, and that means it's written off the books completely, never to be charged to you again. The remaining amount, so not more than $1,500, is to be deferred, and that deferral is over 24 months at least, so the balance of your lease or 24, whichever is the lower, and that would leave that particular tenant having to pay $3,000 a month. So they've gone from having to pay $6,000 a month to having to pay $3,000 a month, of which $1,500 was written off, and the other $1,500 will be deferred for at least 24 months after the COVID-19 period and the substantial recovery period. So we don't yet know exactly when that period will be, but at the moment we're working towards aligning it with JobKeeper. So you know that you'll get that rent relief once you've negotiated it with your landlord. You will get that until the end of the COVID-19 pandemic period, plus whatever the government decides is a reasonable recovery period thereafter. So I just thought I'd run through some very, very quick questions that I get asked. So obviously the first one was, is it 50%? Well, you can see from that it's not. It's not 50% of your rent, it is your rent times by your percentage turnover and then 50% of that. Now, that 50% is not set in stone either. So you can, once you've worked out what your rent, your cash flow relief is, you can ask a landlord to waive more than 50%. The National Cabinet have just said it's got to be at least 50%. And obviously that's where the landlords are going. They're not really going any higher than 50%. But also clients have contacted me and said, we've not had a 30% drop. Are we able to negotiate rent relief with our landlord? Well, you're not prohibited. Just because you don't fall under the code doesn't mean that you are prohibited from contacting your landlord and negotiating a rent relief. And you can use the code as a basis. It's just that you're not actually covered by the code. You can't wave it in front of them and say, you have to give me this. So this is where it's just a negotiation. And I am negotiating on behalf of clients who haven't had a major business interruption yet, but who know that there is one coming. I've had some good success with that as well. And some people have asked me when they have to start paying back that deferred rent. So basically the government have said that it's got to be for a minimum of 24 months and after COVID-19. So I had one landlord who'd offered his tenant 50% rent relief for 3 months and then told them that after the 3 months they had to repay that. So they would be paying their full rent plus the 50% after the 3 months. So that was wrong on a number of levels. So we went back and we've now got them the 6 months at least of 50%, of which half of that is waived completely. So it's written off the books with them. And the final question people keep ringing me to say is, can I just stop paying my rent? And my advice to them is no. The reason I'm telling them that is that if you can pay some rent, then pay it, because the code actually says that both parties have to act in good faith, and that a material failure by the tenant to abide by substantial terms of their lease would forfeit any of the protections provided to the tenant under the code. So if you stop paying rent and then turn around and say, well, you know, you should have given me a rent relief of X amount, the landlord could actually turn around and say, well, no, because you don't get the code protection now because you did the wrong thing by us. So there we go. So it's questions now once we've finished on either topic.
Okay, so if there's no more slides, can you stop sharing your screen, Helen, or have you got a contact slide there, or? Okay, so now let's have some questions. There was a lot of things covered in there. Just as I said, keep in mind this will go out as a webinar and a podcast and be public and on social media and all of that. So if you've got anything that's confidential or that you don't want to go public, then wait until I've stopped the recording, please. So, but any questions? Can I ask one on terms and conditions? Because this is a failing that I see with a lot of business owners, in that they've just been doing business for so long without terms and conditions for getting payment. And it's not until a problem arises that they even come up with think about it. So Helen, is there a sort of a template set of terms and conditions that people can use to make it easy?
Yeah, there's not a typical lawyer answer. There isn't a template per se, because even I have at the moment 12 different starting points essentially. So I'll have one for electricians, one for plumbers, because they have different issues when they arrive on site and different things that they need the customer to warrant, different disclaimers, industry related things that need to go in. You can, I think there are some online companies where you can draw one off, but what you then need to do is go through it very, very carefully, either yourself or with a solicitor, to make sure that it does match your actual requirements. I do see time and time again where people send me their terms and conditions and they've sort of been cobbled together from maybe a competitor, maybe one that their mate had and one that they've sourced, which might reference laws of California, etc.
Yeah, that would be interesting. Yeah. Yeah, so it needs to be tailored for the business.
It does. And I actually offer some packages. So There's different levels of packages, you know, review your terms, or, you know, I can sell some terms, or I can actually bespoke draft for that particular business. Most people after speaking to me realise the value in getting them bespoke drafted, because when I question them and say, you know, what issues do you face? What issues have you faced in the past? They need to make sure that those are actually covered, because no one knows their business like they do.
Sure, yeah. And it's well worth the upfront cost just to save any dramas down the track, I would say. Just coming back to sort of overlapping a bit with what Peter was saying, I know with people who are doing things like website development, and where there's quite a long time frame involved and a lot of work involved, and maybe stage payments. If a stage payment doesn't get made, you know, this reserve the right to suspend services you talked about. You know, I know it can be quite difficult sometimes for people like Peter to just say, well, that's it. We're not going any further, not making your website live until you pay more money. I mean, what's the legal standing on that?
So that again will come down to contract law, and contract law would be what you have in place with that client. So the terms that were agreed before you started providing the services. So for example, if I work with Peter and you know, have a look at his terms and conditions, etc., I'm going to make sure that there is the ability to, and very clear description of how stage payments are to be made, and then the rights if a stage payment is not made by the due date, and if that right is to stop, you know, down tools and stop work, or even stop hosting a website, things like that, then as long as they're in the contract and they were easy to understand for the client, then that's the terms that client agreed.
Okay. So again, it comes back down to having an upfront agreement or a contract in place that both parties understand. I'll keep asking questions until somebody else puts their hand up. Okay. Like with
Is that a hand up there from Steve?
Okay, Steve, go for it.
Okay. I have an engagement letter for accountants that I give to clients when I start a new client. Should I put my terms and conditions in that, and that would it be covered?
So my recommendation to my clients, so after I prepare the terms for them and we go through them and get them really finalised, I then tell my clients how to use them. So my recommendations are always, one, that you have them on your website, so they run along that bottom banner. So as Peter would know, websites normally have website terms of use, which dictate how people can interact with your website, and copyright, and no defamation, all that type of thing. There's usually a privacy policy, which is required by law if you collect personal information. And then the third thing I want on that banner is your business terms and conditions. That way, if people find you online, they're already pre-groomed essentially to knowing what your terms are and knowing what they're in for. The second step, once you've got some terms and conditions, is to make sure you send them out with your quote or your proposal, statement of work, whatever you call that first touch point of quoting a client. And then I actually do say that finally, I would send them out with your invoice as well. Then once you've paid a lawyer to do them, you might as well send them out as many times as you can, and just have them in your MyOb, Xero, whatever system you're using to send out quotes and invoices. They don't get changed every time. The way in which you make changes and the way I draft them is that anything in the quote specific to that client overrides the terms and conditions, but the terms and conditions stay as is. So you can have them as a PDF and easily upload them everywhere you want.
Yeah, I have. I don't have them on the invoices yet, but I was thinking of putting them on. But if I just put them in the engagement letter when a client just first comes on board, would that be enough? And then if anything happens in the future, would it be covered, or do I need to put it on the invoice as well?
I'd do as many as you can, if you can do that. But the fact that you could prove, so let's say there is an issue and you phoned me, and then you can forward me the email that you sent to the client with the engagement letter with those terms, and then the client maybe has emailed back and said, yes, go ahead, or the client has electronically signed or scanned that back to you, then that's fine. At least you've got, that is the contract with the client. The other thing on that basis is to make sure that your terms and conditions, your engagement letter, allow the client to accept your terms in a number of different ways. So not just sign and return. You say that these terms are accepted in these scenarios, 1, if you continue to engage us to provide the services. 2, if you pay a deposit. 3, if you let us know either by email or electronically that you wish us to go ahead. So there's actually deemed acceptance in case things go a bit too quickly and you don't actually have a signed, scanned copy.
Oh, okay. Yeah.
Okay, Steve Wilkinson had a question.
Then
Basically, my question was, how do you present the terms and conditions to your customer, which you've just answered. I mean, I've got them on the website. Now, I send out quotes. So if a customer sends me a purchase order, I send them the goods. I've never sent my terms and conditions separately. Should I send those with my quote?
Are you selling goods online, Stephen?
Well, I do sell online, but I sell microscopes. So if I have an order from a company and it's based on a quote, they send me a purchase order and I send the goods out. Even though the terms and conditions are on the website, I don't send them out separately directly to that customer. So should I be adding them as a PDF when I send the quote?
Yeah,
absolutely. When I send them the invoice?
Yeah, so there's 2 ways to do it. If somebody is ordering off your site, then you can have those terms and conditions that you say are already on your website. You can have those as online terms and conditions, which means that for somebody to start processing a purchase order through your site, they have to accept the terms and conditions. You know, when you tick the little box to go to the next stage. So that's something that your web designer will be able to help you with, and I'm sure Peter would as well. And then I guess the second touch point would be if you then have to manually send out a quote as well. I would attach them to that. I'd have them everywhere so that you can very easily put your hands on them and say, look, this is where the customer saw them and agreed to them.
okay.
Can I just chip in there before Peter speaks? I'll let you have a go, Peter, don't worry. Who's, like Steve made a point there, he sends out a quote, then the organisation will then send a purchase order, which will have their terms and conditions on, and now you're supplying whose terms and conditions apply, the purchase orders or your quote or your invoice, or which one is the legal one?
It all comes down, well, it comes down to 2 things, John. Timing of when the contract was accepted by the client. So if at that stage they've only had yours, then they've accepted yours. If they then later go, oh, there you go, oversight on our part, here's ours. Well, the contract was formed and acceptance was made with your terms. The second one is if that is happening, and this is something that you remember I said about talking to the clients to find out what happens in their individual industry. If that is something that's happening time and time again, then what we need to make sure is that there's a clause in your terms and conditions that say that they are, 1, override any other terms to the extent of any inconsistency, and 2, that they are constitute an entire agreement between the parties, and that no other representation or a document comes into the contract, essentially. So
if the purchaser, does the purchaser have to sign the quote or anything, or the fact that they're actually placing an order, does that mean they have deemed to have accepted the conditions of the quote? Yeah, I mean, that would be a reasonable inference. You send somebody some terms and then they then continue with the services. It's better not to have inferences, it's better to have a contractual trail. So it is better to have that clause in that I suggested before that says if you do any one of these things, which includes accepting the services, it's deemed acceptance of the terms. Now that download that I mentioned with the 7 key clauses, that I believe that one of those is that deemed acceptance clause, so you can all have a look at that. Okay, terrific. Peter.
Oh, thought you were going to forget me. So
Never.
I had a physical bit of paper and I talk about payment plans, blah, blah, blah. And down the bottom for the full story on our terms and conditions and a link. So is that acceptable? So that hits my inbox and I open that up as a PDF, no? Well, in some instances, okay, so I've got 2 scenarios where I'm actually sitting with a person physically, like they're right beside me, and I've run them through, sold them the gig, and then we're actually filling in my my agreement. And so I have a link to my terms and conditions, which if you look at my websites, they're quite extensive. They're massive, 57 pages of whatever it is. So, is that acceptable? I've got a link saying there's the full story, and, so by signing this, you're accepting those.
Okay, my answer to that, based on the fact that at the time they were signing the contract, they may not have had access to that link. So if you've put, say, 6 pieces of paper in front of them and it has a link there and they've not actually been able to read them, then they're not actually at the point where they could say that they've read and understood your terms and conditions. So my thoughts would be, if you can, send that out to them before they arrive with you. Mm-hmm. Or have them printed out. Just have one copy printed out next to you and hand it to each person and say, these are the terms and conditions. If you want to have a quick read, I'll go make myself a cup of coffee.
My agreement, I take what you're saying. My agreement's a simple one-pager. And it's just, in a sales process, sending out your terms and conditions before you meet with someone. Yeah, I
think so. Just make it all part of the process.
Yeah, but, like you're going to send out your terms and conditions, like it's off-putting at best.
Well, it's a business way of, it's a professional way of doing business.
57 pages long. Yeah, pretty off-putting, I think.
Well, yeah.
Okay, let's, I'm conscious of the time, so Jody?
Waving.
Yep, Jody.
Hi, Helen.
Hi.
If a client engaged someone to do a service or to buy a product for them, and they got a quote with the terms and conditions on it, and they proceeded with that, what if that client then went back to that provider, I don't know, a few weeks or a few months later, and proceeded with more services, but hadn't received a quote for the second lot of services or the second lot of product? Are they deemed to have accepted the terms and conditions for the whole entirety of their relationship, or is it just for that one particular section that they've quoted on?
That's a really good question, Jodie. And again, it comes down to what's written in the terms and conditions. So when I prepare them, I do cover that scenario off and say that these terms and conditions cover future services as well. Just in case, because returning client, like you say, might go through a different funnel of, how you onboard them for the next job. So yeah, I make sure that covers umbrella. Just got to make sure that if you do update your terms and conditions, that they get a new copy of them.
Okay, thank you.
But if it wasn't covered in the terms and conditions, what would most likely happen?
Well, lawyers would have a nice argument about case law in that particular state, about whether a court deemed acceptance and whether they deemed previous terms and conditions. I mean, from a practical perspective, if those were the only terms and conditions presented to that client and those were and they engage with you again, then I think it'd be hard to argue that they weren't bound by those terms. But it's not as clean as that trail of, this is the services you've asked, this is the price, and here are our terms.
Okay, interesting. Let's wind it up for the recording and the podcast. Helen, how can people get in contact with you, please?
They can email me at helen.k@riselegal.com.au or visit my website www.riselegal.com.au.
Okay, and I'll be putting out the recording of the video with some links that you've provided so they can download some resources as well. So thank you for that. So I'm going to wrap up here for the sake of the webinar and the podcast. If you're watching this on the recording, then there'll be various things pop up here where you can go to other videos in the series, and you can subscribe to my YouTube channel. And I look forward to you doing that. So there will be another Lunch and Learn in a couple of weeks' time. If you're interested in my mentoring groups and following up with me on anything, then please go to johndenton.com.au or email me at john@johndenton.com.au. So thank you very much for being on board, and I hope you got some great tips and ideas from this.